Hi, I'm Paul Hedgie, CEO of the San Diego County Medical Society, and I want to welcome you another in our series of webinars from the Medical Society, today in partnership again with the Doctors Company, Understanding Malpractice Risks for Mps, PAs, and Supervising Physicians. This has been a very popular webinar with some other county medical societies, and so we wanted to be sure to share it with you. Normally, I would encourage people to put questions in the chat or actually in the Q&A. There's a Q&A function on the app that you can use. So please put your questions there, and at the end of the program, I will ask those and some questions that we received in advance. Kathleen, why don't you kick us off?
Thank you, Paul and Jennifer, and welcome to all of our guests this evening. My name is Kathleen Stillwell. I'm the Senior Patient Safety Risk Manager with the Doctors Company, and we appreciate you taking the time. You've worked all day and you're probably tired, so put your feet up, get something cold to drink, and spend the next hour and a half with us. We're going to go through our program, and then we are going to have a Q&A period at the end. I've already mentioned that this is a CME program. Our program tonight, Understanding Malpractice Risks for NPs, PAs, and Supervising Physicians. We are disclosing that Rich and I are employees of the Doctors Company and that we have no conflict of interest and nothing further to disclose. I have an extensive background in clinical risk management. I'm not going to read our bios. Suffice it to say, you will have access to a copy of the slides that I believe Jen will be sending out. And we would also invite you, if you have any questions about the program tonight, you will have a contact information and email at the end of this session. Along with me tonight is my distinguished colleague, Richard Cahill. He is an attorney and Vice President, Associate General Counsel with the Doctors Company. I can't imagine anybody I would rather present a program with than Rich. We do many programs together. He's an extraordinary professional attorney and a gentleman. He has a background, in fact, in healthcare litigation for more than 35 years. He's been a malpractice defense attorney. He's been involved in professional liability, managed care contracts, network privileging, and has been an attorney, a defense attorney for some of the largest health plans in California, Cigna plans, Kaiser Permanente, and the Tenet Health Systems. He has a very impressive trial and arbitration history, and we are thrilled that he is with us tonight and that he supports the Patient Safety Department, as well as he has many other responsibilities with TDC. He writes many articles, and if you visit our website, you will see that. And of course, he also oversees the appellate litigation and lectures frequently around the country. I always like to start with a thought that gets us all on the same page. And my thought tonight comes from the BC period and the Chinese philosopher Confucius, who said, "To know what you know and what you do not know, that is true knowledge." Our objectives tonight are to recognize the most frequent risks that result in a malpractice claim for the NP, the PA, or the supervising physician, to look at strategies to decrease your liability, to discuss the California scope of practice requirements for NPs and PAs, and also to understand the value and importance of communicating effectively with patients and the healthcare team across all cultures, identities, race, religious, and gender. So who are the advanced practice providers? Tonight, our program is focused on the top two, physician assistant and advanced practice registered nurse. We also have certified nurse midwives, certified registered nurse anesthetists, and anesthesiologist assistants. And what do they do? Did you know that advanced practice providers perform up to 84% of the tasks that are considered to be in a physician's domain? The most recent data we have is from May of 2021, so that's data that comes in from 2020 and earlier. The U.S. nurse practitioner force at the end of 2020 was 325,000 nurse practitioners in the workforce. 88.9% were in family medicine, 81% see full-time Medicare patients, 78.7 were seeing Medicaid patients, 59% see 3 or more patients per hour, which is substantially less, by the way, than physicians see. And it's projected that by 2025, that we will have 375,000, that's another 50,000 NPs by 2025. But I have seen more recent data. I didn't use it because it wasn't published yet in a journal that I could cite, but they are saying, in fact, that it's not going to be only up by 50,000, it's going to be up by as much as 100,000. And in 2018, the last year we have data for, there was 1.06 billion visits reported with nurse practitioners. There are 11 states that restrict practice for nurse practitioners. Those are the red states. And of course, that's California. And California is catching up because we passed legislation last year that will take effect in January 2023 that we will also be talking about tonight. The green states have full practice. That means if I'm a nurse practitioner, I can hang out a shingle and run my own practice. The reduced practice is in the yellow states. In those states, I will be restricted in the scope of practice, or I may need a supervising physician. Right now in California, you need a supervising physician. That has not changed. The 2020 US workforce for PAs was 148,560. So of course it's less, but that's still a strong workforce. The top 5 states in 2020, the most recent data we have, New York was number 1, followed by Minnesota, Maine, Pennsylvania, and New Hampshire. And one of the things you will note is that the presence of nurse practitioners and PAs is higher in the areas in states that have rural and outlying areas, critical access hospitals. And so seeing the movement into the urban and suburban marketplace in healthcare has been in the last 5 years. I thought this was a fascinating bit of information. The fastest growing occupations for 2020 through 2030, I want you to see that the 4th one on the list is nurse practitioners. And in fact, it's the only healthcare occupation that's even listed. And this was a government study, and they were saying that we will have to increase by this during the 2020 to 2030 period by 52%. And so you can see it's a really growing and emerging practice. The benefits of advanced practice practitioners, certainly lower operating costs, increased physician time for more complex cases, improved patient education, increased medical record documentation, cross coverage, on-call coverage. Patient satisfaction is high with these providers, and you can reach a larger number of patients. I also want to say that NPs and PAs have lower claim frequency. Historically, the doctor's company has always insured for malpractice PAs and PAs and NPs who work for a medical doctor or a practice that we insure. We have never before insured standalone nurse practitioners. There are no standalone PAs, by the way, in the country at this time. Even in the states that have, we insure in every state, and many of the states, as you saw with the green states, have independent practice of NPs, but we don't offer independent practice. That is going to be changing in June, and I'm not here to market insurance, but just to say that the doctor's company, with the change in the laws, will have a standalone policy available for nurse practitioners and nurse midwives. But right now, I want you to see this slide is accurate. NPs and PAs have lower claim frequency than physicians. And part of that is there are not as many physicians. They don't work on the most critical patients. So there's all kinds of explanations for that. But when we look at what are the top contributing factors to patient injury in our nurse practitioner closed claims, I want you to see that it's patient assessment. 40% of them, there was an issue in patient assessment. 27% of the claims had selection and management of therapy, 18% a failure or delay in obtaining consult or referral. And this article does not come out from the data in the doctor's company closed claims. This is a national study, and they take data from all different malpractice companies. So what are the liability concerns if you're a supervising physician, if you're an NP or a PA? You do not want to see these advanced practice providers have too much responsibility. They should not have inadequate supervision. You must have written protocols. And if there is deviation from written protocols, you will have a hard time defending that with the, if there's a litigation, and you'll hear more about that from Rich tonight. And failure and delay in seeking referral or physician collaboration is a big one. I could have put it at the top. Nurse practitioners and PAs who don't ever collaborate, and they never need to, and say, this last year I never had to collaborate with anyone, that's a concern. The top 5 risks for advanced providers is, this comes from our claims: failure to consult a supervising physician, failure or delay to obtain specialty consultation or referral, failure to perform an adequate patient assessment, failure to follow established protocols, and last, a failure to adequately document the medical record. Although I want to say, as one who does a tremendous amount of medical record documentation review, I rarely have any recommendations for nurse practitioner and PA documentation. It's not very common that I have many recommendations. Now, we did a study in 2018, and we haven't done one since because there aren't enough claims to study. And we had, from 2011 to 2016, we only had 67 NP claims. And the top 3 allegations, 32 of them were diagnosis related. That's a failure to diagnose, a delay in diagnosis, or a wrong diagnosis. And also embedded in that is a failure to refer. Because if you don't refer and you miss the diagnosis, that can be a delay diagnosis. 16 of those 67 claims were medication related, 11 were medical treatment related. So I think that this shows what a great job the PAs and the NPs are doing, because they're working for doctors we insure. And also, I want to tell you that typically what we see in a claim where the NP is the person who did the treatment, rarely does a plaintiff attorney name the NP or the PA. They just name the doctor and the group, the entity. Why? Because you're the supervising physician. And so it's not very often that I see an NP named. And I have a background in claims, and even in claims, I haven't seen many times, unless it was a more egregious error, then I see the nurse practitioner claims. Just like they don't name the nurses, they don't name medical assistants. These are employees of the group. And so the physician, the supervising physician, has responsibility, and then the group has responsibility for the oversight. And this comes from that same doctor's company closed claim study. And what I wanted to show you was, out of those 67 claims, the percentage of claims came from these top diagnoses. And it's not very many. Look, 8% MI. The rest are all 6%. But colon cancer, breast cancer, lung cancer, those are the top most frequently diagnostically missed diagnoses and treatment for physicians as well. So it's not surprising to me that it's there. And then pneumonia, PE, infarction, sepsis. The top medication management injuries out of the study, this is big. 80% of those 67 claims for medication, and there were 16 claims, so there weren't a lot, but 80% of those claims were adverse reaction to meds. And if you drill down into it, you know what it was? We didn't have accurate allergy information, or we didn't ask the patient, have you ever taken this drug? And either they said, I don't know, I don't remember taking it, or I took it, did you have any problems when you took it? And so I just want to say that's a good place to go for the PAs and NPs that are listening tonight, is to ask people, have you ever had it? The other things are not that relevant, so I'm not going to spend the time to go through them. You will have access to a copy of these. The NP claims with top contributing factors, and I put a red star at the top 3. And this was for all of the 67 claims, all 67 claims. 45% of them, patient assessment was a contributing factor to the malpractice allegations. Patient factors were 30%. What does a patient factor mean? That can be a patient basically who's non-adherent. They don't do what you tell them to do. You tell them to come back, they don't come back. You told them to go get a chest x-ray, they didn't do it. You tell them to take their meds, they're not doing it. You tell them, it's non-compliant. And this is for patients who come back and are your regular patients. You may be in an urgent care setting where they don't come back. And you have to ask yourself, do we do follow-up on urgent care patients? If I come to your urgent care clinic and I see the nurse practitioner, she says, okay, I want you to follow up and come back in 10 days or call us. If I don't come back and I don't call, do you have anybody that will call me? Because you should. Because you cannot be if something goes wrong and I die, my family will sue you. And then they're going to say, why didn't you follow up? Well, we told her to follow up. And I don't think you're going to hear the jury and the people that hear that story feel comfortable with that. And I would like to ask Rich, our attorney, to chime in on that. Rich, how does that play out when people hear the story that we didn't follow up? Can you chime in on that?
It becomes problematic. And in fact, Friday of last week, I submitted an article for publication to a national journal that will be published sometime in the next 30 days, which address that very issue, that jurors expect professionals, particularly in the urgent care and the emergency department setting, if somebody is told to follow up, they expect the professionals to also follow up to make sure that, particularly if there are labs or imaging studies that are done, that the results of which come back after the patient is discharged, to make sure that the patient is aware of the lab or imaging study results. Because even though patients are told to follow up, it's incumbent upon the professionals to make sure that there's optimum continuity of care to follow up with the patients. Yes, you can say that the standard of care was met, but jurors, in the vast majority of cases, want to find in favor of the healthcare professionals. You want to make sure that you've done everything you possibly can. And we win probably 75 to 80% of our cases because we're able to demonstrate that we comported with a community standard. But jurors want to make sure that we've done everything we can to make sure that they were protected and that we did the appropriate thing to make sure that they were treated appropriately.
Thank you, Rich. And what I want to add on to that is be sure you documented the follow-up. And it doesn't have to be the doctor calling. It doesn't have to be the NP or the PA. A clerk can call and say, Mr. Cahill, you were in our urgent care, and I'm just calling to follow up. Did you go get the chest x-ray? How are you feeling? What are you feeling? I'm also going to tell you this is about the patient experience. And the patient experience is enhanced. People say, gee, they called to check on me. And this goes for your private office practice as well. And you might think, well, we don't have the staff, we don't have the time to do it. If you think you're too busy, then you have to look at the patients that are most critical and triage. Maybe if it's something that can wait till the next visit versus do you need to know? And if people are not following up, you need to write what they say. And when I do the training for staff, I would say this: if you called someone and said, Mr. Cahill, did you go and get the labs drawn and get the x-ray? And Mr. Cahill says, no, I don't have time to do that. I'm going to just wait till the next time I see the doctor. Then the person should say, okay, I'm going to put a note in your chart that that's what you're planning to do, and I will let the doctor know. And then you put in patient inquired about a follow-up with labs and x-ray, patient responded in quotation marks. No, I'm not going to do that now. I don't think it's important. I'll just wait and follow up with the next visit. And then I tell the doctor, I called Mr. Cahill. He said he didn't think it was important. And it's the doctor or the PA or the NP who has to say, okay, I think it's important to follow up. If it was your family member, would you follow up on him? That's kind of the standard that I use. The mother standard, my gold standard is what would I do for the person I love dearly? And you don't have to love your patients, by the way. But what would you do? What would you want the group to do? What would you want the urgent care to do? So 30% of the time, the claim was because the patient was a problem. They didn't do what they should have done. Selection and management of therapy was 27%, and that's the provider decides on that. The physician, PA, NP, that selection and management of therapy is what you decide. And is it wrong, or should it have been something else? I mean, things can fall in a lot of categories. I do want you to see the next one is 19%, communication between patient or family and provider. And this comes back to communication. And did the patient understand the message? Did the patient get it? One of the things I say is when you have to tell a patient, after this visit, there are 2 things I need you to do. The first thing I want you to do is say the first one, most important one first. Research shows say the most important one first. Also, when you're telling your friends, your family, your children, your friends with benefits, tell them the most important thing first. The most important thing I want you to do is I want you to get this lab test, and then I will get the results in the office and we will get back to you after we get the results. Second thing I want you to do is come back in 2 weeks. Okay? So what we're doing is we're saying the most important one first, and also have it backed up when your patient is discharged, and your MA can say, what are the 2 things the doctor wants you to do? He wants me to get the lab, and I forget the second one. And the MA or somebody's usually there, or you can tell them, repeat back, do a repeat back. It's really of great value. Again, then we go on to documentation failure or delay in obtaining consent or referral. And then look at the last one, 10% of the claims were communication among providers. And part of that had to do with not going to the supervising physician. Now the PIAA, I don't have any data. We've never done a closed claim study on PAs because we don't have enough claims to do one. But the only study I can find, and nothing has come printed or published since that I could find that I felt was not anecdotal. PIAA is now MLA, Malpractice Liability Association. This was the old bedpan mutual. All of the insurance companies, including TDC, contributed our closed claim data anonymously for them to do studies. And the only one they ever did was on PA, and they did a separate one on NP. So I put the numbers together to show you in a 10-year study that they didn't have that many claims either. But you can see that it was pretty even for the NP and the PA as well. But the number one, error in diagnosis. And diagnostic error is the leading cause of malpractice lawsuits. And it's found in over 33% of all malpractice lawsuits, that we can find an allegation for an error in diagnosis, which could be misdiagnosis, delay in diagnosis, or an error in diagnosis. I want you to look at the second one, which is improper performance. And this is a skill thing. The person didn't do it right. And 90 of the claims, a PA was involved, in 41 an NP. The rest of the numbers, I'm not going to go through them all, except for one other one I want to look at is medication error. 48 claims with med errors, 48 and 35. The numbers are pretty close, but still, again, this demonstrates the great care that PAs and NPs are doing out there. Now, comparing PAs to physicians and nurse practitioners, what we look at is based on 17 years of data from the National Practitioners Data Bank, that physician assistant malpractice demonstrates lower malpractice incidents compared to MDs and advanced practice nurses. But I'm going to tell you that we can make nothing much out of this, because there's only a third of the number of PAs as malpractice claims, of course. So to me, it's not very practical to even share this, except to say that the volume of nurse practitioners is much higher than we have with the PAs. I'm now going to go back to Rich, because I want our legal eagle to talk to us about theories of liability. Rich?
Thank you, Kathleen. Good evening, everyone. My name is Richard Cahill. I'm Vice President and Associate General Counsel with the Doctors Company. Kathleen and I recently submitted an article on this very topic, and you'll, if you Google our names, sometime in the next month, you'll see an article that discusses these various topics. I think it's important, before we go through the various case studies, that we talk about the background from a legal standpoint as to what a plaintiff's attorney must demonstrate to a reasonable degree of medical probability. There are 4 components to a professional liability case that a plaintiff's attorney must demonstrate to a jury, an arbitrator, or a judge trying one of these cases. The first is duty. And what is that? It means that there is a legal obligation between the doctor and the patient. Is there a doctor-patient relationship? And if so, there is an obligation that certain things have to be done. And that is, they have to establish that the doctor had to comport with the community standard, do what other physicians similarly trained would have done under same or similar circumstances. When I first started doing this work in the early 1980s, it was a local, community, or regional standard. Now it's a national standard. It used to be, well, what was done in Bakersfield was the standard. But now what is done in Bakersfield is the same standard that must be done in Los Angeles, New York, or other parts around the country. In other words, if there is a breach in that standard, it's the same standard that must be done everywhere across the country. That's established by independent expert testimony. Plaintiffs' attorneys tend to use physicians from the academic environment, from university settings, and they will get someone with an impressive academic university resume. In my experience, and I did a lot of this work for 20 years, I would get community-based physicians who would say, we're familiar with the standard of care based upon our many years of experience. Most defense attorneys would use community-based physicians. Jurors tend to appreciate that because community-based physicians know what's being done in the community around the country. The next thing they have to establish is causation. In other words, a link between the alleged breach in the community standard and some compensable injury. And then the final incident is damages. And they have to establish to a reasonable medical probability that this breach in the community standard caused damages. And in most states around the country, the causation is to a reasonable medical probability. And that's the standard in California. Some years ago along the East Coast, they established a different standard, and that is a much lower standard was established, where it was just simply, is there some breach that was less than to a reasonable medical probability? California follows the majority standard. Dumas versus Cooney is the case. Oregon follows a much lower standard that simply says, is there something that had a different degree of care, would it have had a better result? Fortunately, we use a different standard in California. Damages fall into 2 categories. One is general damages, pain, suffering, life isn't as good as it used to be. California, we're limited to the micro standard of pain, suffering, loss of enjoyment of life, and that's capped at $250,000. Some states, it's unlimited, and they use what's called the per diem argument, and they say to the jury, ladies and gentlemen, Timmy has an injury that he'll have for the rest of his life. How much is that worth? $100 a day. And then they proceed to argue that that $100 a day is worth many millions of dollars if you multiply that time the life expectancy of this young child. $100 a day times 70 years comes out to be many millions of dollars. In California, as in the remainder of the states, there's also economic injuries, loss of past, present, and future. Excuse me, I'm having some problems with my audio. Loss of earnings, earning capacity, and also perhaps some type of injuries related to hospital and other economic injuries. Those are not capped by MICRA in the state of California. So what type of damages might there be? Direct liability, a physician or other healthcare provider is alleged to have caused these various damages. There could be agency or vicarious liability. For example, a medical group is held responsible for an employee. Negligent supervision, and frequently that happens where a medical group or a physician is held liable for negligent supervision of someone, for example, a physician's assistant or advanced practice provider. Negligent credentialing, a group is held responsible for negligent supervision or credentialing of an employed physician or an advanced practice provider. And those, they're attempting to find a separate degree of responsibility, perhaps a separate policy limit, and attempting to get an additional an amount of money against one of the other named providers. So let's take a moment and look at some various case studies that Kathleen will put up for us, please. The first case study involves a 54-year-old male with history of treatment of a toe with liquid nitrogen by a dermatologist 1 week prior to the visit in question. The patient complained of toe pain and a fever of 101 degrees. The nurse practitioner wrote in the chart viral illness and ordered Tylenol, PRN, for fever. There was no documentation that a toe assessment had been done. And remember the old adage, if not documented, it was not done. The patient was discharged home, and there was no documentation by the nurse practitioner in the chart that there was an examination of either the foot or the toe. 3 days later, the patient returned and was hospitalized with severe sepsis. The patient was admitted for 9 days in the intensive care unit. Respiratory support was required. Patient was placed on dialysis. Several foot surgeries were required. Unfortunately, given the lack of documentation and the ultimate diagnosis, the patient had a settlement by the facilities as well as all the providers, given the lack of documentation. Well, what did the independent experts on both sides, plaintiff and defense, said? Number one, it was uncontroverted that the documentation by the nurse practitioner was poor. There was no comment or any observation regarding the painful toe, which was reported both by the patient and family members as having occurred. There was no assessment that was documented during the visit by the nurse practitioner, and ultimately, it was uncontroverted that there was a delay in diagnosis and treatment that resulted in severe complications. Case study number 2. A 30-year-old male, morbidly obese, fell on a knee and presented to an urgent care. The patient was evaluated by a physician's assistant. The MRI showed a dislocated patella. H&P noted a family history of deep venous thrombosis and lupus. A surgical consultation was ordered. The patient presented and returned to the urgent care. 8 days post-op on a Saturday with complaints of difficulty walking with pain in the left leg. The patient was discharged home with Norco and was advised to see the surgeon the following Monday. Unfortunately, the patient died suddenly. Because of the situation, an autopsy was done and revealed a pulmonary saddle embolus. On the postmortem, a DVT was diagnosed in the leg with a 3-inch larger calf circumference. On review of the PCP's medical records, it was documented that he had a genetic increased risk for DVT with a diagnosis of lupus. The family claimed that they had told the PA in the clinic that the patient's mother had died from clotting disorder and that the patient had reported the same condition No documentation by the PA on that discussion, or that there had been any mention of a clotting disorder by history. The expert said that the standard of care was not met during the urgent care visit, that a poor history had been obtained and recorded, that there was an inadequate assessment based upon what the family had reported, and the fact that there had been no measurement of the calf of either leg, and that on discharge there was inadequate follow-up instructions. It was a wrongful death case brought by the family, and the case settled for a substantial amount. Scope of practice. Scope of practice of both the physician assistant and the nurse practitioner. It's clear that they must meet the physician and the employer's job description. They must adhere to the policy and procedures established by the employer. And it may not include the entire scope allowed by the state regulations. The employer must establish very clearly in the policy and procedures what is expected of both the nurse practitioners and the physician's assistants. Both the NP and the PA and the supervising physician should review the job description. I've had many cases over the years in representing both Cigna and Kaiser, where the physician would say, I did not review the job description. I just assumed that the physician's assistant and the nurse practitioners knew what their jobs were and that they were following that. That is not a satisfactory response. The physicians are responsible for knowing what the job descriptions say. And if they don't know what that is, they will be held responsible for what the job descriptions actually said. The nurse practitioner, the physician's assistant need to sign off on that annually so that they can demonstrate that they reviewed it and they knew the delegation of duty agreement as well as what the protocols actually said. They will be questioned about that at the time of deposition. I direct your attention to California Senate Bill 697, which is incorporated in the Business and Professions Code, which defines the responsibility of professionals in the healthcare industry in the state of California. That became effective in January of 2020. The PA Delegation of Services Agreement replaced with practice agreement in the organized healthcare system, defined as hospital, clinic, home health care agencies, physician offices, medical foundations, and professional medical corporations, any setting where medical care is lawfully provided. Any physician within the supervision, any PA subject to a practice agreement. It must include the type of medical services the PA is authorized to perform, including communications, availability, consultation, referrals with physicians, and so forth. In my experience, both Kaiser and Cigna have very detailed protocols which indicate what the physician's assistants and the nurse practitioners must do and are very specific as to the responsibilities that the physicians must do in supervising the advanced practice providers. They're very clear on those responsibilities. Supervision means licensed physician and surgeon only. Supervised physicians are not required to be physically on site. They may be available by phone or electronic communication. Physicians may supervise up to 4 PAs. A PA may furnish or order a drug in accordance with the practice agreement and consistent with the PA's education or clinical competency. It must specify which PA may furnish a drug or device, under what circumstance, extent of the physician's supervision required, and method of periodic review of the PA's competence. Do not confuse the agreements. A physician's practice agreement is not the same as an advanced nurse practitioner's standardized procedures. Nothing in the regulations requires the physician to review or countersign the medical records for patients treated by the PA unless specifically required by the practice agreements. Practice agreements shall be signed by the PA and the supervising physician. Agreements may designate a PA as an agent of the supervising physician. Scope of practice. The board holds that the nurse practitioners are accountable for knowing and practicing within their professional and individual scope of practice. In a hospital facility-based practice, practices that serve medically underserved population, there is no limitation on the number of nurse practitioners or PAs to whom a physician may delegate prescriptive authorities. Keep in mind that both PAs and nurse practitioners must adhere to federal and state regulatory compliance regarding HIPAA, cures, open notes as set forth in the 21st Century Cures Act, billing requirements, and medical record documentation. AB 890, independent nurse practitioner practice in California as of 2023. First, must pass a national certification exam, complete transition to practice program, 3 full-time equivalent years of practice, 4,600 hours of clinical experience and mentorship, maintain professional liability insurance, verbally inform all new patients that the nurse practitioner is not a physician. And early on in my practice, that had become an issue because sometimes patients were not aware that an advanced practice provider was not a physician. In those days, my clients were very careful in making sure that the patients were aware that advanced practice providers were not physicians and made sure that they wore appropriate documentation, either in the form of a badge or otherwise, that the advanced practice providers were just that and that they were not physicians. And so that was very important. Also, posting notices in conspicuous locations accessible to the public that the nurse practitioner is registered by the Board of Registered Nursing. The California Nurse Practice Act allows nurse practitioners working under approved standardized procedures to provide primary medical care, prescribe drugs, order medical care tests and devices, cosign first report of occupational injury or illness for workers' compensation claims, request disability parking placards, and manage patient care. Medical record supervision. Interesting issue. Do nurse practitioners and PAs patient charts need to be countersigned? The law does not provide a specific number of percentage of charts that must be reviewed. The number of charts reviewed may be an important factor in determining the quality of physician supervision. Do my patient charts need to be countersigned by a physician? The Nurse Practice Act in California does not require physician countersignature of nurse practitioner charts. Some malpractice insurance carriers may require physicians to sign nurse practitioner charts as a condition of participation. Some standardized procedures may be written to require physicians to countersign charts. How often do standardized procedures need updating? They should be updated frequently enough to ensure patients are receiving appropriate care. In your practice, consider reviewing at least every 3 years. Physicians Nurse practitioners and PAs should sign off every year. Factors to consider in making the determination to update: patient population and acuity, your treatment modalities, and advances in pharmacology and diagnostic technology. How many nurse practitioners with a furnishing number may a physician supervise with a medical practice? The furnishing law requires that physicians supervise no more than 4 nurse practitioners at a time. If the nurse practitioners are not furnishing, there are no limitations on the number of nurse practitioners the physician may supervise. That's set forth in section 2831.1.
Thank you, Rich. Before I move on to understanding cultural bias, I want to bring up a couple of points that, Rich and I get hundreds of calls a month. And one of the most frequent calls I get in relationship to nurse practitioners, more often than PAs, because there are more nurse practitioners than PAs. And it's a doctor who calls and says, I know I'm supposed to be supervising the nurse practitioner, but I don't know who I'm supervising. We have multiple sites and I don't know who these people are. And then I get a call and I answer the questions, but is that really supervision? I said, well, have you ever met the person? No. Have you ever heard of them before? No. Have you ever reviewed the delegation of duty agreement? What's that? No, I haven't seen that. How about, have you ever reviewed the protocols that the nurse practitioner works under? No. I said, okay, well, there's some really good opportunity then to help engineer the risk that you're operating under, because if you were deposed in a lawsuit and you had to say the answers you just gave me, you wouldn't be able to defend yourself as a supervising physician. So what you need to do always, and everybody that's in this program tonight might not be with a large group. You could be in a small group. You can have one site, but you might say, I don't know when I'm supervising. I'm on vacation. Am I supervising? Can they call me when I'm on vacation? Those are all things that are determined by you and your group. But the thing that is non-negotiable is that you should have a list of who the NPs are in your practice. And if you're supervising, then and you can't supervise more than 4 at a time. And you can't, and then I get this call. I'm supervising 4 NPs and I'm supervising 4 PAs. I just want to run that by you. I said, I'm glad you did. That's not going to work. The rule is 4, and you can't do 4 PAs, 4 NPs. It's 4. You can do 2 PAs and 2 NPs, but you can't do 8. You can't exceed 4. So that's important to understand that. The other thing comes back to this furnishing number. You may not use the physicians with a NP with a furnishing number, may not use the physician's DEA number. You have to have your own DEA number to furnish controlled substances. And I know that there's a lot of change in what we're seeing in the prescribing of controlled substances, but that's important. Another frequent call that I get is, well, do we have to still have the physician keep co-signing or countersigning records? I said, well, why are you doing that? Well, because that's what our agreement says. I said, when did you write your agreement? I don't know. Can you find a date on it? Oh, they give me the date. I said, that's 18 years ago. A lot of laws have changed. You should be updating your agreement and looking at it. Do the laws change every few years? Yeah, they do. But most importantly, if you put into your agreement in the past that you had to countersign or review X number of records, then you have to do that, and you have to be sure that you can prove that you did it. The other thing that physician practices tell me is, well, we bill under the doctor's NPI instead of the nurse practitioner because reimbursement is higher under the doctor. And I said, okay, well, somebody needs to do the math, and then I will tell you you're losing money because the increased reimbursement against the time for the doctor to have to sign off is cost prohibitive. So you have to do your own internal analysis of what are we doing and does this make sense? The doctor's company doesn't tell you how to practice medicine. We don't tell you what you have to do. But we tell you the consequences if you don't do things right and if you don't follow the letter of the law. Another big thing that's come up now because of the law that has changed for the independent practice of the nurse practitioner in 2023 is I have practices calling me and saying, when the law changes in 2023, does that mean that our nurse practitioners have to be independent practicing in our group? And the answer is only if you want them to be. And then they have to have their own separate liability policy. You're paying for them anyway already. And maybe they have their own insurance because they're going and working somewhere else, 8 hours a week or on a weekend or doing something for another group. Maybe they have their own insurance. Did you ask them? I know a lot of NPs who say I work 3 days a week here and 2 days a week there. I go and do volunteer work, or I go to a federally qualified clinic and I do things and I have my own insurance. So you want to be aware that you're going to be the one that decides how you're going to handle an independent practice. You can bring an independent nurse practitioner in now. It's a 1099 and they may have their own insurance, or you may add them on your insurance, or you may also then have a vicarious liability rider on there. Rich, could you say something about the vicarious liability exposure for someone who has a 1099 NP or PA?
Well, the difficulty is somebody is an independent contractor, particularly in California, you may be responsible for them, depending upon the setup of the office. For example, somebody may be an independent contractor in your office, and you may be responsible for them, even if they have a badge that says, Dr. Cahill, and you have to be very careful about that. So, I can't provide legal advice on this, but that becomes problematic.
Thank you, Rich. But what you can do is check in with your insurance broker. If you're with the doctor's company and you purchase direct from us, then our insurance services offices can help you understand that. But one of the big risks down the road for physicians, and now it's also an issue for physicians who may have a 1099 nurse practitioner or PA who has their own independent insurance. So I want to tell you a little story. The doctor called me and he said, I have this practice and I have a 1099 nurse practitioner. She has her own insurance. She works for me 3 days a week. And I've just opened another clinic about a year ago that is about 120 miles from here. And she's now working there 1 day a week. I said, did you add her on to your doctor's company policy that she's working at that other clinic? No, because he did have the vicarious liability. She had her own insurance, but he added the vicarious liability coverage. And I said, okay, well, you have to do that. He said, well, I didn't know that. I said, well, if you don't ask, you won't know. So I hooked him up with the person at in insurance services who added that location, that address on to his policy. Because interestingly, he hadn't told us that he had opened that policy or that office either. He thought that his office manager did, but we didn't have it in our records. So that was all fixed and it was covered and everything's good. Then he has a problem and the patient wants to sue, and he's relieved because it happened at this other office 120 miles away. And he called me and he said, good news, bad news, Kathleen. Bad news is I have a patient in my office at the other location that's going to sue. The nurse practitioner took care of the patient. I wasn't even there. It was a Saturday. The bad news is she has insurance and her insurance isn't going to cover it. I said, and why would that be? She never disclosed to her insurance company that she was working at that address. Said, remember we went through that with you? Yeah. Did you ask her to notify her insurance No, I didn't even think of it. I said, you wouldn't because you're a doctor. You're not a business operations person. So what I want you to all hear is if you have 1099 people that you want to be sure that their individual insurance company, and you want proof from them that they have notified. The proof can be a confirmation letter from their insurance company. That's what I tell doctors to get. Say, I want a copy of something from them. And so that's important because, Rich, what does it mean if they're not insured and then they get a denial? The nurse practitioner's insurance company says, I'm not going to cover it because you never disclosed it. It would be like if I got a new car and I'm driving it and I didn't tell my insurance company and I have an accident, they're not going to cover it. How will that work? Who's going to be responsible for the litigation, the expense, and the indemnity, Rich?
They may well look directly to the physician and expect the physician to be responsible for it. And then it becomes a very difficult issue.
Exactly. So when we get to the Q&A, if you have any questions about that, I have to bring up understanding cultural bias. I'm bringing it up for two reasons. First of all, we have another law, and this law that took effect January 1 is now part of the Business and Professions Code in California, which governs, as Rich said, the practice for healthcare professionals. And that means it's not negotiable. And what it says in this law is that any accredited CME program has to meet certain standards for inclusion of content that relates to culturally linguistic competence and implicit bias. And the medical board charged the California Medical Association with creating the standards. And so the doctor's company, we are an accredited provider and we are accredited with distinction, which is the highest level. So every program that we give CME for, we have to have some content about this. And in fact, we have company, we insure in all the states in the country, but California is the only state that has this law. And I was talking with our CME department the other day and I said, I don't think that people in all the other states are going to appreciate that they have to listen to this because of a California law. And I think there'll be a lot of non-CME programs. And if I don't include something, I can't get verified and approved for CME. So I want to point out how it's important for you to understand. I'm not going to read the definition for cultural linguistic competency. It's a tongue twister, but it's basically that you tailor your communication, your staff's communication, and your interaction and engagement with patients, visitors, their guests that come with them, and you are respectful and observant of the diversity in values, beliefs, culture. And I know you do that already because we don't see any claims for discrimination. Now, discrimination, Rich, I don't even know is that covered under the malpractice policy?
If it's a statutory violation, at least under our policy, it would be excluded.
So we're not going to cover it if you get sued for discrimination. If you have employees who discriminate, then you're going to have to consider, do I need employee practice liability insurance, which is very expensive and I think has a minimum $150,000 deductible. So everyone is careful and conscientious, I believe, in healthcare with being mindful of not being discriminatory and being respectful, especially in the communication with people. A lot of times patients have a perception that's different than the reality, and it's really important. And I had a call today to give us an example. Two things about this call. One, the patient was very upset and said that she thought she was seeing a doctor and she saw a nurse practitioner and she was really mad. And on the way out the door, she started screaming at the receptionist and using some very vulgar language. And she said, "You're liars and you don't even know what you're doing." And the staff person, of course, was just struck by, oh my gosh, and had never had any training about how to respond to people like this, which is, I'm sorry, we have a zero tolerance for that language and disruptive behavior in the office. I want to help you, but I have to ask you to please tone it down. and let me see how I can help you. Well, this young lady just broke down in tears, and then she was ridiculed by this person. And then somebody in the lobby said, who was waiting in the lobby, said to this patient who was exiting, "Hey, don't talk to her like that." And then this patient turned around and fired on that person and made a very nasty comment to her, acknowledging about her ethnicity. And everybody was embroiled, and then that patient stormed out of the office. But we're left with 11 people sitting in the lobby, upset by what they've observed. The young lady at the desk who's crying, and nobody knows what to do. How do we take care of people in these situations? You have to be sure that your staff is prepared. The patient that yelled at the patient that was waiting, that patient now is being, the lobby patient's being consoled by another lobby patient, but nobody in the practice knew what to do. You want to be sure that your practice knows what to do, knows how to handle these situations, and most importantly, that you know how to document it. And by the time they called me, the doctor called me because he was seeing patients, and this was an hour later that he learned about it. And he called me and said, "What do we do?" I said, "The most important thing is how we're going to document what happened and who's going to document what." And this patient, he goes, "Well, I'm going to throw this patient out." And this patient was a post-op patient. I said, "You can't just throw her out. She's post-op. We're going to do a warning letter, and I'll help you with the warning letter. And then the warning letter is going to say, we have a 0 tolerance for disruptive behavior and inappropriate language in the office and in the phone, on the phone. And if it occurs again, we will have to dismiss you from the practice, because otherwise you're going to get these people, they retaliate and they call a grievance in to their health plan. They make a complaint to the medical board, and then the whole new party begins, and you're sucked into it. And you better have the documentation within quotes, the nasty thing the patient said. Implicit bias, that just, we all have built-in bias. So I'm not going to go through this definition, but attitude, feelings, stereotypes, feelings positive or negative. We just need to be sure that it's not, we can't wear our heart on our sleeves, can we? I think doctors don't have much problem with this because they really understand how to do that. But where I find the problems that we're encountering, it's with the staff. Is your staff aware of the need to control their behavior? Is your office manager educating your staff to say, you can't have a knee-jerk reaction? I had someone last week call me and say, somebody jumped all over the receptionist at the front desk, dropped the F-bomb on her, and she said it right back to her. That's not okay. But you can't blame the young lady at the desk. She had never had any education about it, and nobody had put anything in the medical record about what the patient said. And then they said, do we have to write in there that she said it back? I said, no, this was a patient they could dismiss, and that was dismissed for cause. So that was important. The cultural issues and beliefs that are listed in this standard that we now deal with include all of the things on this list. And notice income. Income is important. Well, many practices see people who are homeless. You have patients who are homeless who are in Medi-Cal, they're on care, they might be getting from the VA, they have insurance, their family buys insurance, so they'll get care. And I don't get a lot of calls about this, but I get a number of calls throughout the year that somebody came in who, we don't want to treat him. He's obviously homeless. He smells. We can't bring him in the office. Everybody's disgusted. What are we going to do? Well, you have to have a plan for how to deal with these patients. Maybe you say, come back, we'll have you be the last patient of the day. They just walk in. We can't see you now, but we'll have you be the last patient of the day. So we want to be respectful. Compassion, empathy, that's what you're known for. I know as clinicians, physicians, PAs, NPs, I don't get any calls about you disrespecting people, but we get hundreds of calls a month where staff is being criticized or staff is being disrespected. And I want to remind you that as an employer, you have a responsibility to protect your employees from a hostile work environment, or they have grounds for a lawsuit against you. Rich, what does a hostile work environment claim look like?
Well, I don't really work with that type of an environment, but it's a situation in which someone feels that because of the behavior of a coworker or a supervisor, they feel like they're being disrespected or treated in a difficult way, and they believe it's pervasive, or it may just simply be a one-off situation. They report it to a supervisor. It's not treated in a respectful way. It can be a very expensive endeavor for the employer, and it can also be very expensive for the individual supervisor or manager as well. So it's something that employers need to take seriously. And California has training for employers as well as managers that's required on an annual basis.
Yes, if you have 5 employees or more, you are required annually to have sexual harassment training. And there's a couple of other kinds, there's safeties, there's a lot of things that are required, but we won't get off topic. Thank you for that, Rich. And your malpractice policy doesn't cover you for that, by the way. Recognizing health literacy and language issues, I want to say something that, first of all, if you are going to be doing examination of private parts and up close and personal with a patient undressed, please have a chaperone, and a family member or someone who is with the patient is not appropriate to be a chaperone. They can be in there, but you're going to have to bring somebody in, and not for the whole visit, just for 3 or 4 minutes for that time while you're examining that part. And it's important because I will guarantee you, if we have litigation, and Rich will chime in when I'm done here, Rich, if we say we had that there was a chaperone, and if it's not documented that Kay Stillwell, MA, I'm the medical assistant, present during examination, if that's not there, and the family says there was nobody in there, nobody was even in the room, the patient says that, and their family says it wasn't, how do we get out of that?
Well, there's no way to recreate that somebody was present. And the article that I did at the end of last week, one of the comments that I made is that you need to have some way to recreate that, either by putting K Stillwell or KS some way, so that you can recreate through employment logs that the person was present and be able to identify it at some later date.
That I was working that day. It's really important. The other thing that's very important, if you have a patient who does not speak English, you need to have a translator. Now, maybe you have a staff member who can be the translator, and it doesn't have to be a certified translator, but it should be a qualified translator. And when people ask me, how do I know if they're qualified? Well, are they, they have to tell you, I'm conversant. For me, I am conversant in Spanish very minimally. I would never hold myself out as a translator. But when I worked as a nurse back in the day, many years ago when I was a nurse, I worked as a translator in a hospital, but it was very limited. We didn't have certified translators then. But what you want is, you don't want to use the family. And if you don't have someone in your office that can help you out, the AT&T language line is available 24/7. They have 750 dialects. They have, I think, 430 languages and 750 dialects that you can use. And you need to document who was the translator in the patient's medical record. I want to give you a story. I had a few weeks ago a call from a physician. He said, I just stepped out of an office to talk to you. He was a fertility expert physician. And he had a young lady who came in. She was in her mid-30s with her husband, did not speak English, and the husband said, I will translate for her. And he just said, well, I don't have anybody here that speaks Farsi anyway, so you can be the translator. And then he began his interview and had gone through. The patient had already gotten a lot of tests done before she came for this visit. Her OB doctor had them done, and he was to discuss the results, and he was doing some examination on her. And he was relaying everything in English, and the husband was translating. The MA was in the room. Then all of a sudden, the patient starts crying and sobbing. And the doctor has no clue, because he's just saying, you know, he said, I was telling her, I think we're going to have a success in having you get pregnant. I would recommend we do an artificial insemination and with your husband's sperm. And I think I'm very optimistic about your chances to conceive. And the patient's crying. And he said he could tell that she wasn't crying tears of joy. She was hysterical. The MA tapped him on the arm and said, can you step out for a moment, please? And so he said, excuse me, we're going to step out and give you a moment. Stepped out, and the MA said, I didn't want to tell you, but I do speak Farsi, but I'm not really good at it, and I didn't want to be the translator. And everything that you're telling the patient, the husband is making it the opposite. He has told her, there's no way you'll ever get pregnant. There's no reason to have any further visits. This is the last step. And he doesn't think that you should consider adoption. He was saying all kinds of things that were totally irrelevant. The doctor didn't want to go back in. He called me on my cell phone. He goes, what should I do? I said, go in with the MA and have her, and you just say, my MA just told me that your husband has been translating inaccurately, and I would like to, and then she was doing the translation. He said, and as he started getting into it, the husband flew into a rage, grabbed the woman's purse and the woman and dragged her out of the office. And that was the last they saw of her. But you see, you don't know, and this is not the first time I've had a call like that. You don't know what that translator is saying. And so you need to have a translator. And the more serious the problem, the more important. Now, someone asked me the other day, how do I know what a qualified translator is? I said, what you might do is ask your local hospital, what qualifications do you have to be a translator? Because if you work in a hospital, they send out something that said, if you feel that you're conversant, and they have different, are you conversational? Are you expert? What are the different levels? And what is the vocabulary you have, et cetera? And they might share with you what they use. Some hospitals, if you go to that hospital, they may, on occasion, I've said, try and call your hospital. But the AT&T language line is really the very best way. I also want to tell you that it's been almost 10 years now that the California Managed Care Department in California passed a law that if a patient is a member of an HMO or a managed care plan, the managed care plan or the HMO have to provide the translator. And the problem with that is they come to the visit and they don't know that. So if a patient is an HMO patient and they make an appointment, and the best thing to know is when they are a new patient, you're with an HMO. Do you speak English? When they call for an appointment, do you speak English? Or they're calling for their family member. Does she or he speak English? No, they speak Chinese. Okay, well, we don't have any Chinese translators. What you need to do is contact your health plan and arrange for a translator, and then to ask them how much time you need, and then call back and we will schedule the appointment when they can have the translator. And sometimes it's as far as a week out. I've had some that can do it in 3 days. I've some say we need 2 weeks. And then they get a translator, and it's on the phone. And it's just they have a phone, and you put it on a speakerphone, and the translator is there, and it's a 3-way. It's just, but you don't pay for it, and the patient doesn't pay for it either. The managed care plan has to provide it. So it's important that your staff is aware to ask people when they're making an appointment, do you need a translator for the patient? Because many times the person that's calling is not the patient. So that's important to be sure that you have a translator. 50% of patients.
Before you move forward, I need to make a correction. I want to thank Kevin Hirsch for putting this in the chat. Regular California employment law, sexual harassment training and other management training is required every 2 years. I know that's what we do at the Medical Society with our payroll benefits and others. You had said 1 year earlier. Yeah. And I just remind everybody here that malpractice coverage does not do employment law coverage. We all, like Med Study and others, we have our own employment insurance and coverage and needs to follow those rules separate from anything you hear here in malpractice and
Thank you. We don't give
medicine recommendations.
Yeah, we don't do
And
legal.
also, I just want to point out the time. We have a lot of questions we wanted to try to get to.
Okay.
We're at 7:20
We're just
now.
coming right up on the end. And I just wanted to say 50% of patients reported physicians sometimes listen to their concerns. 80% of patients responded that they felt advanced practice providers always listened. There was a study done. Physicians did well on patient satisfaction. So it was a national survey, scored 7.2 out of 10. NPs received a near perfect average score of 9.8 out of 10. This is how perceived they are by the patients. There's no significant difference between PAs and NPs. I think we've already talked about satisfaction. We've talked about reducing your risk through credentialing, through working together, and I don't think that there's anything new on these last couple slides. So let's go back to the questions that we have. And Paul, do you want to let us know what they are?
Yeah, I will do that. First, for everybody, I'm putting in the chat again the link to claim your CME credit, and want to, in advance, thank Kathleen and Rich for the presentation today, and Genome Center at the Medical Society for putting all of this together yet again. First, I have a question for Rich. Do I need a signed delegation of duty agreement with every individual NP? Do I need a separate practice agreement with individual PAs?
One for the entire group is sufficient, and as I'd indicated, and I think Kathleen mentioned it as well, as long as you have that done on an annual basis, where the physician and the PA and nurse practitioners sign that every year, that's sufficient.
Great. If I'm out of town and in another state, can I still be a supervising physician for an NP in California?
That's fine as long as you're licensed in California. That's perfectly okay. Occasionally, we have physicians will say, "Well, I'm going to be out of the country." Well, that's probably not a good idea to be calling back into California if you're out of the country. But as long as you're licensed in California, your insurance, that's not going to be a problem.
Perfect. And I think you answered this, but I got this question. How many NPs can I supervise at one time?
A maximum of 4 advanced practice providers.
Thank you. That's exactly what I thought. Kathleen, for you, as a supervising physician for NPs, I may not know who I'm supervising on a given date. Does that matter?
Well, maybe it does, maybe it doesn't. What you should know on the date, the NP should know on the date I come to work as an NP, I need to know who is my supervising physician. And what I say is, hey, send your supervising physician a text. Or if I recommend that you keep a list, whether it's at the urgent care or in your office, if it's rotating to different supervising physicians who are at other sites, you just post it once a month. These are the supervising physicians. So you should be able to have a place that you can find out. So the answer is the supervising physician should have a place that they can see who they're supervising. It might change, but they need to know, how do I know who I'm supervising?
Perfect. My medical group does not plan to have NPs work independently inside the group. Will NPs be able to work independently beginning January 1, 2013 or 2023 if they are part of a medical group?
Yes, under the law, they will be able to if they meet all the criteria that was on that slide. Additionally, the question will be, does the group want to keep them as an employee, or does the group want to have them as a 1099? And many of my groups are saying, we're going to just keep them as employees, and you're not going to concern, about, they don't have to have a supervising physician, but we're going to keep them as independent. They can still be an employee, and they're looking at, should I have vicarious liability? And those are all things that you have to decide by talking with your broker or deciding the organization. But I see a lot of different combinations.
As supervisor of PAs, I thought I had to review or countersign the medical records created by a PA.
Only if that is in your PA agreement. And don't put it in your agreement, and then you don't have to. But you do have to do supervision and periodically look. And most of the time what I see is that it might say review 4 records per month per PA. That's fine. You don't have to look at 100.
Yep. One of the questions that came in, what new law comes into play in 2023 regarding MPs, PAs? It's only MPs, and I think we've covered that. If you want to add in anything.
Yeah, it doesn't apply to PAs.
Correct.
The new law.
If you can't get a translator, can you refuse care, or is that discrimination?
You can't refuse care because you can get a translator, because AT&T has 24/7 availability.
And Kathleen, do you have access to that phone number? That was the next question here.
You can just look it up on any Google search engine.
Just Google.
Translation.
I just found it as well. It does require payment, FYI, but you can Google AT&T translation services, and it was the top response.
There is a payment, and they also have a plan where you can pay a certain amount per month and have usage, and you cannot charge the patient for the translation cost. That's why I say if they're HMO or a managed care program, they will provide the translator.
A follow-up to an earlier question, on the out-of-state physician supervising, but they have a California license, that apply to PAs as well. And they supervise PAs from out of state if they have a license, a California license?
Yes. You're only required to be available by phone or electronics. So you can be available by the phone or on a computer. You don't have to be in person. And as Rich said, we have many physicians who, are out of town, out of state. But if you're on vacation, you don't want to be a supervising physician either.
Yeah. At the top end, when you had some studies on claims related to other providers, were PA studied independently for MPs? Are there numbers in terms of claims similar?
PAs are much lower, but that's why I said that it was the PIAA study that I showed. They're lower because there are not any studies out there. There's no big study to do. And there are so many fewer PAs than NPs. So the PA study, that's why the numbers were so low. NPs have more because they do more service. We have 325,000 plus NPs, and we have 165,000 PAs. So you're going to have more claims with the NPs. But again, and what Rich and I see at the doctor's company claims is if there's a claim involving an NP, the plaintiff attorney brings it against the supervising physician, right, Rich?
Well, what they try to do is they try to add as many policies as they possibly can. So they'll add as many physicians as they can. They'll add the group if they can. And they probably won't add the nurse practitioner or the physician's assistant unless they can somehow add another policy to it. So same way when they're suing a hospital, they rarely will name the individual nurses in that situation, because they'll sue the entity and they will try to establish liability to the entity by claiming that one of the employee nurses, technicians, or otherwise, they're responsible for them under a theory of vicarious liability.
And seeing as we're approaching 7:30 here, I will, Kathleen?
I wanted to, if I could, Paul, if there are no more questions, are there any more questions?
I was going to throw one more in. Often
Okay.
in the ED urgent care setting, the patient is instructed to follow up with their primary care provider if not improving, or returning to the ED if worsening. what would you say is the responsibility for the ED urgent care to follow up on a patient to see if they got better or not if there were no outstanding labs or studies?
It's always
no
based
outstanding
upon,
labs or
Rich,
there's
go
no
ahead with that.
outstanding lab, it's always what the community standard is in that situation. And if the community standard is that you ordinarily wouldn't follow up with the patient following discharge, then that's what this community standard would require. It's probably something that you in the community would know whether or not in the urgent care setting or the emergency department, whether that's something your peers would have done. But it's probably helpful to, at least in your written instructions, which you would document in the chart that you gave to the patient, follow up with your primary care physician in 3 to 6 days, or if you see any of the following signs or symptoms developing, return to the urgent care or the emergency department within X number of hours or days. That way, if there's any problems that develop, the patient is on alert as to what to be done. And then any problems that develop, the patient is aware of that.
That's a good answer.
Okay.
Was a good response. If we have no more questions, I want to very quickly remind you, if you want CME credit, you have the link available to you in the chat. You have the scan of the QR square, and I think that Jen is going to send out the slides and the link as well. I want to let you know that many times people call and say, I did the evaluation and I didn't get the CME certificate right away. That's because it's open to do the evaluation until 5 p.m. on March 30th. And my assistant, Julianne Miles, she is an eager beaver, and she will probably first thing in the morning be sending out certificates, but then more will trickle in over time. And they will come to the email address that you put in your check-in. If you have any problem with that or you need any assistance, her name and phone number and email address are on the slide, or you can call me. I want to tell you, thank you so much for being here. And if you are with the doctor's company and you have any interest in having any training for your staff on dealing with disruptive patients, we provide that training. And I also want to say that one of the most important things to say is thank you for being out there throughout this pandemic. It's been a brutal time to be a doctor and to be in healthcare, and we're most appreciative. I hope you all stay well. And we want to thank the San Diego County Medical Society for inviting us into your home, into your family, and we hope that we will see you again in the near future. And thank you, Rich.
And I will just throw in, if you're a physician and not already a member of San Diego County Medical Society, please go to our website, SDCMS.org, and join.
And I think you recorded this, and the recording will be available by requesting the link by an email to the Medical Society. Is that right?
Yep, that is correct. SDCMS@SDCMS.org, and just put it in the chat again.
Thank you so much. Have a great rest of the evening.
Thank you, everybody. Good night.